Okay, by now you probably know that the Supreme Court of the United States has refused to grant cert in any of the election cases related to the 2020 presidential election, an outcome that I suggested was the most likely back when these things were being filed. It was not likely that the court would go ahead and hear these cases. Now, when I said that, though, it wasn't because the court doesn't or shouldn't hear those cases. I think the court absolutely should hear at least some of them. But I just figured, based on the political environment, even though the court's not political, they would go ahead and decline to hear any of the cases. They would decide that they were either moot or whatever, and they were no longer necessary, and we don't really want to get into it, right? The court right now is in a little bit of a weird place with the potential for court packing coming over the next 2 years, which we'll talk about in a separate video. But they were not going to hear these cases. It was too much of a political hot potato. That being said, we do have Justice Clarence Thomas to thank for a rather insightful and a very thoughtful dissent on why some of these cases probably should have been heard. Now, this is in the context of just one case out of Pennsylvania, and it's not the case that I actually wanted them to hear. I wanted them to hear Kelly versus Pennsylvania, but that case was not heard. There is no dissenting opinion or anything like that given on it. We don't know the numbers. We just know that the hearing on that one was denied. In this case, Thomas gave extensive comments in a dissenting opinion, and they're all great, but I'm going to read just a little bit of it. Just 3 small sections. The intro, one part of the body that I found very interesting and very important, explaining Thomas's reasoning as to why the court should have heard this, and then the conclusion of it, just for completeness. Now, he's not the only one who dissented. Alito and Gorsuch also did, which means that Kavanaugh and Amy Coney Barrett both voted not to hear this case. So, if you remember, Robert Barnes had said that Amy Coney Barrett would not be an ally to Trump in this, and would not vote to hear any of this stuff, that she would not take on the election law cases. Robert Barnes was absolutely correct in that assessment when he told people, don't put your faith in her to save anything about any election. Amy Coney Barrett is not going to do it. That's not in her sort of philosophy. And he was absolutely right. By the way, you should check out Viva Fry and Robert Barnes's weekly podcasts, because they're always full of insight and intrigue. And if you want to hear about legal stuff, you need to check them out. They're over on Viva Fry's channel here on YouTube. I'll link it down in the description below. I'll also have a link to this document in the description below if you want to read the whole thing for yourself. And I encourage you to do it. But I am going to go through the whole thing on a live stream very, very soon as well. It's just going to take a little while. Okay, so this is a Republican Party of Pennsylvania versus Veronica DeGraffenreid, which would have been versus Bookvar. But Bookvar had to step down due to problems managing elections. Go figure that happened. So here we go. So they said they granted all of the leave to file amicus curiae. They granted leave to file the petition for cert, but they denied the petition for cert, so it doesn't matter ultimately. Justice Thomas dissenting from the denial. Here's the intro that we're going to read real quick, and then we'll move to that next spot. He says, the Constitution gives to each state legislature authority to determine the manner of federal elections. Yet both before and after the 2020 election, non-legislative officials, both before and after, non-legislative officials in various states took it upon themselves to set the rules instead. As a result, we received an unusually high number of petitions and emergency applications contesting those changes. The petitions here present a clear example. The Pennsylvania legislature established an unambiguous deadline for receiving mail-in ballots, 8 p.m. on Election Day. Dissatisfied, the Pennsylvania Supreme Court extended that deadline by 3 days. The court also ordered officials to count ballots received by the new deadline, even if there was no evidence, such as a postmark, that the ballots were mailed by Election Day. That decision to rewrite the rules seems to have affected too few ballots to change the outcome of any federal election. But that may not be the case in the future. These cases provide us with an ideal opportunity to address just what authority non-legislative officials have to set election rules, and to do so well before the next election cycle, The refusal to do so is inexplicable. Thomas writes in a very, very soft and polite style. And the way he writes this, though, is absolutely incisive to the actual opinion of his colleagues on the court. You can tell that Thomas is not happy about this. The refusal to hear it is inexplicable. Why wouldn't we hear this? And then he goes ahead and goes through some reasons. We're going to cut to kind of the middle of it to talk about some of the really important reasons around this. But again, I encourage you to read the whole document or join me for the live stream in which we'll read the whole document as well. Okay, so here he's talking about the expansion of mail-in ballots, all right? So this is where the mail-in ballots comprised just 4% of ballots cast in 2018, but it was expanded to 38% in 2020. So we're going to pick up right here. This expansion impedes post-election judicial review because litigation about mail-in ballots is substantially more complicated. For one thing, as election administrators have long agreed, the risk of fraud is vastly more prevalent for mail-in ballots. The reason is simple. Quote, absentee voting replaces the oversight that exists at polling places with something akin to an honor system. End quote. And that's from, then we have Heather Gerken, now dean of the Yale Law School, explained in the same New York Times article that we were just quoting from, that absentee voting allows for, quote, simpler and more effective alternatives to commit fraud on a larger scale, such as stealing absentee ballots or stuffing a ballot box, which explains, quote, why all the evidence of stolen elections involves absentee ballots and the like, end quote. The same article states that, quote, voting by mail is now common enough and problematic enough that election experts say there have been multiple elections in which no one can say with confidence which candidate was the deserved winner. Pennsylvania knows this well. Even before widespread absentee voting, a federal court had reversed the result of a state Senate election in Pennsylvania after finding that the supposedly prevailing candidate, quote, conducted an illegal absentee ballot conspiracy and that the election officials covertly facilitated the scheme with the specific purpose of ensuring a victory for that candidate. Now, that's a case from 1994. So there's no claim that this happened in 2020. Thomas is just using a prior case from Philadelphia where this actually happened. Go figure. Absentee ballots have been a problem for a while, and this is, of course, everybody's concern with them and why the court's refusal to address them is so troubling. Going on, it says, this problem is not unique to Pennsylvania, and it has not gone away. 2 years ago, a congressional election in North Carolina was thrown out in the face of evidence of tampering with absentee ballots. Because fraud is more prevalent with mail-in ballots, increased use of those ballots raises the likelihood that courts will be asked to adjudicate questions that go to the heart of election confidence. Now, he goes on to talk about how fraud is not the only aspect of mail-in ballots that complicates post-election judicial review. I'm not going to read that whole section. Again, this is a multi-page document. I encourage you to check out the link and read it for yourself. But I want to point out that Thomas is very cognizant of the problems with absentee ballots, and more importantly, the problem with having to go back and litigate on those ballots and to potentially have to invalidate some votes. Now, the reason he's talking about this is because he's making the case. This is very important. He's not referring to the 2020 election here. He's making the case that they need to decide this before the next federal election in 2022. That deciding these things ahead of time is critical. Deciding them after the fact is bad. That's what Thomas's point is here. I want to be very clear on that as we go through. And then here is the end, his final paragraph. And again, it goes to his displeasure at what has happened. One wonders what this court waits for. We failed to settle this dispute before the election and thus provide clear rules. Now we again failed to provide clear rules for future elections. The decision to leave election law hidden beneath a shroud of doubt is baffling. By doing nothing, we invite further confusion and erosion of voter confidence. Our fellow citizens deserve better and expect more of us. I respectfully dissent. This is, again, a very big, very good statement from Justice Thomas. It would have been nice to see them dissent, more. I guess it would have been nice to see them hear the case. That would have been wonderful. They're not going to do it, but it is good to see Thomas go ahead and put this out there. Now, let me be clear on, again, why this is important to Thomas. He's not suggesting anything about the 2020 election. He's suggesting everything about elections going forward. He says that these types of cases have a high likelihood of appearing again, even though other members appear to have indicated that these are an unlikely set of circumstances to be repeated, that 2020 is some sort of special anomaly. But the interesting thing about permitting anomalies is that they tend to show up over and over and over again. And he talks about just how many times the Supreme Court has been asked to deal with issues around the 2020 election. And since they didn't deal with any of them, that becomes very, very important. At the core of all this, Thomas is concerned about voter confidence in the election system. I've seen, even on this channel, in the comments, and I would love for you to leave a comment down below about what you think about all this, but I've seen from comments and people emailing me that they have no faith in the election system, and that the Supreme Court specifically refusing to hear these issues has further eroded any sort of legitimacy that the election system held in these people's minds up to this point. People believed that when they cast a vote, they were casting a vote. Now they don't believe that their vote matters because they believe there is something else happening. That erosion of voter confidence is one of the most dangerous things. And if I were a conspiratorial person, I would suggest that bigger than any result in the 2020 presidential election, the idea to cast doubt on the election's integrity itself would be much more damaging to the country in the long run. And that is the type of conspiracy that I think would be much scarier to see because it is much subtler, much more nefarious. But if you dispirit people into not voting, you can effectively control elections forever rather than just one at a time. And so that's something that I think everyone should be concerned about. And Thomas talks about, in this case also, which is of note, he talks about how hard it is to go back, for judges to go back and invalidate votes based on the amount of things that they're presented with in court, and that is a big sticking point and why the rules need to be hashed out in advance. Again, if you've been watching this channel for any amount of time, you know that has always been one of the things I have maintained. Judges don't want to do this, even though by allowing these cases to go through, you could similarly be disenfranchising hundreds, thousands to millions of voters. Because if something improper occurs, like a rule change that happened in Pennsylvania that may have been unconstitutional, if that improperly impacts the outcome of the election. Now, Thomas says in this case it doesn't. This isn't the only Pennsylvania case, though. In this case, it doesn't. But if it does, then you disenfranchise millions and millions of votes. So a judge is left with a very difficult and almost impossible decision after the fact. That's why we have to solidify these rules before the fact. And Thomas is trying to tell that to the court. But again, the court's not going to hear any of them this year. We'll see if they hear them in 2023 after the same cases crop up, leading up to, during, and following the 2022 elections, where I'm sure nothing untoward will happen. No last-minute rule changes, no national emergencies, nothing at all. Nothing ever happens in this country that has any impact on anything else, as we all know. Anyway, thanks for watching, guys. Drop a comment down below. Tell me what you think. And also, make sure you hit that subscribe button. I know a lot of people who watch these videos are not subscribed to the channel. Subscribe. Hit the bell button next to it, and you'll get notifications whenever a video comes out. We have a lot of fun and a lot of information. Talk to you then. Have a good day. Peace. Peace.